12.8 million. That is the number of lawful permanent residents, green card holders, living in the United States right now. 12.8 million people who followed the rules, waited in line, paid their fees, built their lives, bought their homes, raised their children, and earned the right to call America their permanent home. And on June 23, 2026, the United States Supreme Court issued a ruling that cast a legal shadow over every single one of them. Not over criminals, not over people who did something wrong, over all 12.8 million. Because the ruling in Blanche versus Lau did not just change what happens to one man who sold counterfeit shorts in New Jersey. It changed the fundamental relationship between a green card holder and the U.S. government at every single port of entry in the country. It changed what happens when you land at JFK after visiting your mother. It changed what happens when you fly back from a business trip to London. It changed what a border officer can do to you, right there at the airport, before you even have a chance to make a phone call. My name is Mr. Burhan, and this is U.S. Visa News Hub. In the next 15 minutes, I'm going to explain exactly what the Supreme Court decided, why it matters for every green card holder regardless of their background, who is most at risk right now, what questions this ruling left dangerously open, and most importantly, what you need to do before you travel internationally again. Stay with me until the very end, because this is one of the most important immigration videos you will watch this year. To understand what just happened, you need to understand the story at the center of this ruling, because the story reveals exactly how far-reaching this decision really is. Muk Choi Lau is a 69-year-old Chinese national who became a lawful permanent resident of the United States in September 2007. He lived here, he worked here, he built a life here. In May 2012, New Jersey police charged him with trademark counterfeiting, specifically possessing and intending to sell 2,860 pairs of counterfeit shorts. He had not been convicted, he had not pleaded guilty, he had not admitted anything. He was simply charged, which, in America, is supposed to mean nothing more than an accusation until proven otherwise. While those charges were still pending, while he was still legally presumed innocent, Lau briefly traveled to China. He then returned to the United States through JFK Airport on June 15, 2012. When he arrived, a border officer checked the databases, saw the pending charge, and asked Lau about it. Lau denied committing a crime. The officer had no confession. The officer had no conviction. The officer had no clear and convincing evidence of anything. But the officer confiscated Lau's green card anyway, denied him normal re-entry as a returning permanent resident, and instead placed him on what is called immigration parole. That single decision changed everything about Lau's legal situation, and now the Supreme Court has said it was completely legal. Here is why that matters so much. Under U.S. immigration law, there is a crucial distinction between two different legal tracks. The first track applies to someone who is already admitted to the United States, a lawful permanent resident who is home. Under this track, the government bears a high burden of proof to remove you. They must prove deportability by clear and convincing evidence. You have strong procedural protections. You have rights. The second track applies to someone who is seeking admission, someone who is trying to enter the United States for the first time, or who has been reclassified at the border as not yet admitted. Under this track, the rules are completely different. The government faces a much lower burden. The inadmissibility grounds are broader, the protections are weaker, and the path to removal is significantly easier. When a border officer places a returning green card holder on parole instead of admitting them normally, that officer has just moved that person from the first track, the protected track, to the second track, the more dangerous one. Everything that follows, every proceeding, every hearing, every legal argument, is now governed by the harder set of rules. And Muk Choi Lau argued, rightfully, that a border officer should not be able to do that without clear and convincing evidence that he actually committed a disqualifying crime. The Second Circuit Court of Appeals agreed with him, but the Supreme Court, by a vote of 6-3, reversed that. Justice Clarence Thomas, writing for the conservative majority, held that border officers do not need clear and convincing evidence at the time of re-entry. Suspicion of a crime, an unproven pending charge, is enough to press what the court called the pause button via parole while charges play out. This video is for informational purposes only. Please consult a qualified immigration attorney for advice specific to your situation. Most people hear the word parole and think of criminal law, being released from prison. That is not what immigration parole means, and understanding the real meaning is essential to understanding why this ruling is so alarming. When you are placed on immigration parole, you are physically present in the United States, but you are not legally admitted. You are in a kind of legal no man's land, and the practical consequences of being in that status are immediate and serious. First, your physical green card can be confiscated right at the airport. The document you carry in your wallet, the document that proves your permanent residence, can be taken from you at the border based on nothing more than a pending criminal charge. Second, your employment authorization, your legal right to work, can be disrupted because work authorization for permanent residents is tied to their admitted status. Third, you cannot travel further. Once you are placed on parole, leaving the United States again becomes legally complicated and potentially dangerous. Fourth, you have no reliable proof of your status while proceedings move forward. You are in legal limbo, physically here but legally unprotected in the way a permanent resident is supposed to be protected. And fifth, and this is the most devastating consequence of all, once you are classified as seeking admission rather than already admitted, the government can now pursue your removal using the inadmissibility track. That means the government's burden is lower, your procedural protections are fewer, and the path to removing you from the country you have called home for years becomes significantly easier. This is exactly what happened to Muk Choi Lau. He was paroled in 2012. He remained in legal limbo for years while his criminal case moved through the courts. He eventually pleaded guilty in 2013 and received 2 years of probation. And then the government began removal proceedings, not under the deportability track that would have applied to a normally admitted permanent resident, but under the inadmissibility track that applied because he had been placed on parole at the border. He was ordered removed in 2018. 6 years of limbo and then a removal order, all traced back to one border officer's decision at JFK Airport in 2012. A decision that was made without a conviction, without clear evidence, and without the legal protection that a returning permanent resident was previously understood to have. Now here is something absolutely critical that most coverage of this ruling is not explaining clearly enough. The ruling in Blanche versus Lau directly addressed only one of 6 exceptions that can trigger inadmissibility proceedings for returning permanent residents. But the American Immigration Council and multiple leading immigration law firms have already warned that the government is almost certainly going to argue that this ruling applies to all 6. You need to know all 6 right now, because any one of them could affect your re-entry. Exception 1. You have abandoned your lawful permanent resident status. If you have been outside the United States for an extended period, or if the government believes you no longer intend to make the U.S. your permanent home, you can be treated as seeking admission. Exception 2. You have been absent from the United States for more than 180 days. A trip abroad that lasts more than approximately 6 months can trigger this exception and put you on the inadmissibility track at re-entry. Exception 3. You committed a crime while you were outside the United States. If you were accused of having committed an offense during your time abroad, that accusation, under the new Blanche versus Lau standard, may now be enough for a border officer to place you on parole rather than admit you normally. Exception 4. You departed the United States while removal or extradition proceedings were pending against you. If you left the country during any open immigration or legal proceeding, returning can trigger this exception. Exception 5. This is the one directly at issue in Blanche versus Lau. You have committed certain crimes in the United States that make you inadmissible, specifically crimes involving moral turpitude, controlled substance offenses, or other disqualifying offenses. Under the new ruling, a border officer can now apply this exception based on a pending charge rather than a conviction. Exception 6. You attempted to enter without proper inspection. If there is any question about the manner of your original entry into the United States, this exception can be invoked at re-entry. The American Immigration Council has said explicitly that the government will almost certainly push to apply the new, lower evidentiary standard from Blanche versus Lau to all 6 of these exceptions, not just the 5th one that was directly addressed in the case. If that happens, the already significant impact of this ruling becomes dramatically larger. Let me be completely precise about this, because precision protects people. The ruling in Blanche versus Lau does not mean that every green card holder who travels internationally is going to be stopped at the airport. The majority of the 12.8 million lawful permanent residents in the United States are not directly affected by this decision, in the sense that their re-entry will not be disrupted. But there are specific groups who now face meaningfully elevated risk, and if you fall into any of these groups, you need to understand your situation before your next trip. The first group is green card holders with any pending criminal charge at any level in any jurisdiction. It does not matter whether the charge is a felony or a misdemeanor. It does not matter whether it is a new charge or an old one. It does not matter whether you believe the charge is minor or that it will eventually be resolved in your favor. Under the Blanche versus Lau standard, a pending charge is potentially enough for a border officer to place you on parole rather than admit you normally. If you have any pending criminal matter, consult an immigration attorney before leaving the United States. The second group is green card holders with prior criminal convictions, particularly convictions that could qualify as crimes involving moral turpitude. Crimes involving moral turpitude is a legal category that is defined more broadly than most people realize. It includes fraud, theft, certain assault offenses, counterfeiting, and many other offenses that people may not think of as serious immigration problems. If you have ever been convicted of anything, even years ago, even something you believed was behind you, you need to speak with an immigration attorney and specifically ask whether your conviction could be classified as a crime involving moral turpitude before you travel internationally. The third group is green card holders who have been outside the United States for close to or more than 180 days in any recent 12-month period. Extended international absences already triggered the second of the 6 exceptions before this ruling. But after Blanche versus Lau, there is elevated concern that border officers may apply even broader discretion across all 6 exceptions. If your travel history shows long periods outside the United States, understand your re-entry risk before your next trip. The fourth group is green card holders whose cases have any unresolved immigration issue, a prior period of unauthorized presence, an old removal order that was administratively closed, any pending USCIS matter. These situations create complexity that border officers may now have broader discretion to act on. The fifth group, and this may surprise some people, is any green card holder who has ever had any interaction with law enforcement, even an arrest that did not result in a conviction, even a dismissed charge, even something that happened years or decades ago. Border officers have access to databases from international, federal, state, and local law enforcement agencies, as the Supreme Court's own majority opinion noted. Records of past interactions with law enforcement can appear in those databases even when they did not result in convictions, and under the new standard, a border officer has significant discretion in how to respond to what they see. The 3 dissenting justices, Ketanji Brown Jackson, Sonia Sotomayor, and Elena Kagan, did not simply disagree with the outcome. They issued a sharp and detailed warning about what this ruling could mean in practice, and their warning deserves to be taken seriously by every green card holder in this country. Justice Jackson, who wrote the main dissent, described the ruling as handing the government a massive blank check. Her concern was not just about Muk Choi Lau specifically. It was about what the ruling enables going forward. Under the majority's holding, she argued, the government can return a lawful permanent resident to the status of seeking admission upon entry at the border, so long as the government is able to show later that they were eventually convicted. That sequencing, she wrote, undermines the plain terms and basic operation of the law. Think about what that means in plain language. A border officer can decide to treat you as someone seeking admission, strip you of your green card, place you in legal limbo, expose you to the easier removal standard based on information that may never result in a conviction. The conviction comes later, if it comes at all. The legal downgrade at the border happens immediately. And even if you are never convicted, the damage to your status, your employment authorization, your ability to travel, and your peace of mind may already have been done. Justice Jackson also raised a concern that is particularly relevant in the current political environment. that a motivated administration could use this expanded border discretion aggressively across all categories of returning permanent residents, not just those with criminal history. The ruling gives border officers remarkable latitude with very limited immediate accountability. And in an environment where immigration enforcement has been described as a top priority, that latitude is not abstract. It is the power that an officer has the next time any green card holder lands at any airport in the country. One of the most troubling aspects of the Blanche versus Lau ruling is not just what it decided, it is what it left open. The Supreme Court's majority opinion created a new legal standard but did not clearly define its limits. And those undefined limits create enormous uncertainty for green card holders, their attorneys, and immigration courts going forward. The first open question is, what standard, if any, border officers must apply when they decide whether to place a returning permanent resident on parole? The court said officers do not need clear and convincing evidence, but it did not say what they do need. Can they act on pure suspicion with no database record? Can they act on a charge from another country? Can they act on something a traveling companion said? The standard is not defined, and that undefined standard is now the law of the land at every port of entry. The second open question is whether this ruling applies to all 6 of the exceptions that can trigger inadmissibility proceedings for returning permanent residents. The case only directly addressed Exception 5, crimes involving moral turpitude. But as the American Immigration Council noted, almost certainly the government will argue that the same logic applies to the other 5 exceptions. If courts accept that argument, the impact of this ruling expands dramatically. The third open question is whether there is any legal mechanism to challenge an improper placement on parole at the border in real time. If a border officer makes a decision that you believe is wrong, what can you do about it right there, at the airport, before your green card is confiscated and before you are placed in legal limbo? The ruling does not clearly answer that question, and the practical reality is that the options available to you at the border in that moment are extremely limited. These open questions mean that we are in a period of genuine legal uncertainty, and that uncertainty itself creates risk for every green card holder who travels internationally. U.S. Visa News Hub provides immigration news and general information only. Always consult a qualified immigration attorney before making any decisions about your travel or immigration case. Let us end with the most important section of this video: what you actually need to do right now to protect yourself and your family. Because knowledge without action is not protection. The first and most important step is to assess your own situation honestly before your next international trip. Ask yourself these questions. Do I have any pending criminal charge at any level in any jurisdiction? Do I have any prior conviction, even an old one, even a minor one? Have I been outside the United States for more than 180 days in any recent period? Do I have any unresolved immigration matter with USCIS or any immigration court? Have I ever been arrested, even if the charge was dismissed or I was not convicted? If the answer to any of these questions is yes, your risk level under Blanche versus Lau has meaningfully increased. The second step, if you fall into any of those categories, is to consult a qualified immigration attorney before you travel. Not after you book your tickets. Before you make any travel plans at all. An experienced immigration attorney can review your specific situation, assess your re-entry risk under the new standard, advise you on whether it is safe to travel and under what conditions, and help you prepare documentation that could be useful if you encounter scrutiny at the border. The cost of a consultation is a fraction of what it would cost to deal with the consequences of an improper placement on parole at the border. The third step is to gather and organize your immigration documents. Your green card should be current and valid. If it is expiring within the next 12 months, begin the renewal process immediately by filing Form I-90. Carry documentation that demonstrates your ties to the United States, employment verification, property ownership or lease documents, tax returns, evidence of your family in the United States. These documents tell the story of your life here, and they can matter enormously if a border officer is making a discretionary decision about your re-entry status. The fourth step is to understand your rights at the border, even though exercising them is not easy. You have the right to remain silent when questioned beyond basic identification and documentation. You have the right to speak with an attorney, though this right may be limited in certain circumstances at the border. You should never provide false information to a border officer. That creates separate and very serious problems. And if you are placed on parole, you should contact an immigration attorney as soon as possible, because the clock on your legal situation starts moving immediately. The fifth step is to stay informed. This ruling is new. Courts, border officers, and immigration attorneys are still working out how it will be applied in practice. The government's arguments about extending this ruling to other exceptions are still to be tested. Future cases will clarify the undefined standards that the majority left open. The landscape is going to continue to evolve, and staying current with those developments is essential. 12.8 million people woke up on June 24, 2026, with a legal reality that was different from what it had been the day before. Most of them do not know it yet. Most of them will book international trips, pack their bags, and go through airport security without ever thinking about Blanche versus Lau. And for the majority of them, nothing will happen. But for those who fall into the risk categories we discussed today, and there are millions of people in those categories, the next trip abroad could become the most consequential journey they ever take. Not because they did anything wrong, not because they are not permanent residents, but because a 6-3 Supreme Court decision gave border officers broader authority to make a decision that can change everything. Right there at the airport, before you even make a phone call. You cannot change the ruling, but you can change how prepared you are for the reality it created. And that preparation starts today. If this video helped you understand something that matters to your family, please share it right now with every green card holder you know. The person who needs to see this video the most is the one who has no idea this ruling exists. Subscribe to US Visa News Hub and turn on the notification bell, because we will continue tracking how this ruling is applied in practice as real cases emerge. My name is Mr. Burhan. Stay informed, stay protected, and we will see you in the next video.